All right, good morning, everyone.
Morning, Judge.
Morning, Your Honor.
All right, let's get started on our calendar. The first case I have is Engineered Restoration versus TXO Investment Group. We're here for a hearing on plaintiff's request for attorney's fees. Are we ready to go?
Yes, Your Honor. Rich Capriola for Engineered Restorations. We're prepared to go.
Robert Friedman on behalf of TXO. I'm prepared as well.
All right. So I will turn it over to you, Mr. Capriola.
Okay, thank you, Your Honor. 10 days ago, the court entered an order, as you're aware, awarding about $74,000 in damages on summary judgment and making the finding that plaintiff's entitled to its attorney's fees, and this is the hearing for those attorney's fees. So let me, if I could share screen, Your Honor.
Hold on one moment. I'll give you permission. All right, you should be able to share now.
Okay. Let me get the right document. You should have on your screen a document entitled Exhibit Number 1, Plaintiff's Exhibit Number 1.
Yes.
Okay, great. Your Honor, Plaintiff's Exhibit Number 1 is a statement of account for all of the legal fees and expenses incurred on this matter from the date of our initial engagement with the client through, let's see, it's through January 10th. And Your Honor, it is a business record of our firm. It's maintained in the ordinary course. It represents truthfully and accurately the attorney's fees and expenses incurred. And it's our normal practice to maintain these billing records. Your Honor, we seek to admit Exhibit Number 1.
All right, Mr. Friedman, any objection?
No objection to it being admitted or that it's authentic, but I do want to point out that this is the first time that I'm seeing this. Like, it's my understanding that this was never filed. Is that correct, or am I wrong?
Your Honor, would you like me to address counsel?
Yes.
Sure. The time up through the summary judgment was attached to my affidavit. So all of the entries through the date of the filing of summary judgment, which I believe was in September of 2021, so sometime right around here, are filed and attached to my affidavit. The additional time was incurred from the summary judgment forward, and therefore is being attached here too, and you would not have seen it before today. So that's an accurate statement as to the last bit of it. So again, we renew our request to admit the exhibit.
I'm going to admit the exhibit, but I think this puts Mr. Friedman at a little bit of disadvantage since, now's the time where he has an opportunity, to cross-examine as to, the necessity and the reasonableness of the fees. And he hasn't had a chance to see any of that before right now. So I'm not sure that we can address your fee requests in total and give Mr. Friedman a fair shot to respond to it because it hasn't been filed and he doesn't have notice.
Your Honor, the majority of it has been filed and was for quite some time. And at the last hearing, Your Honor, there was the statement made by counsel, something along the lines of he determined whether he wanted a hearing and if he was going to challenge the fees in any way. I followed up with counsel after asking if there was going to be any challenge to the fees. I did not receive any response to that particular part of the request, nor was there ever a request made for a run of my time, in addition to what had already been filed with the court. So, Your Honor, I'll do what the court chooses. If you'd like to push us to the back of the calendar and give them an opportunity to review it, that's fine. If you'd like to reset it for another day, that's fine. We think there's plenty of opportunity to be had this resolved and viewed if there was any interest in it prior to today.
Mr. Friedman, we're going to go forward today. I'm not going to make a final ruling on numbers today. I will give you an opportunity to supplement if you want any further response or further, you have potential cross-examination from Mr. Capriola after you review the updated billing statements. But I think we're at least prepared to go forward with the bulk of the issues today. So let's use that time. All right, so Mr. Capriola, with that settled, anything else that you wish to offer before I turn it over to Mr. Friedman?
Your Honor, I'd offer my testimony, whether stated in my place or sworn in as counsel would request or the court would request. You tell me how you want me to do it.
You can state in your place.
Okay. Your Honor, these are the actual fees incurred. They are reasonable and necessary in order to perform the services that we provided to the client here. The hourly rates are customary for the firm for the work that we do in this area, which is commercial litigation. And they are what is normally customarily charged by our firm for the services. And they are consistent with the Atlanta market for legal services. I'm just approaching 30 years of practice at this point, Your Honor. And my rates charged to this client were between $425 an hour when the engagement first started in 2019. And currently they are $450 for this client for this matter. And the associates, and there were primarily one associate who worked on it, Chad Reynolds. He's been practicing for 7.5 years, and his rates were $295 and now currently $300 an hour for this client. And that is well within the norm and the customary rates for an associate commercial litigator in the Atlanta market for the work and services that we provide. There were two other associates involved. One simply attended a hearing, 3.5 years experience at $270 an hour, and one did a title work at $265 an hour with 6.5 years experience. And those are all, again, customary and consistent with the market in Atlanta. The work that we did, Your Honor, and the billing statement reflects it, but it's a breach of contract case. There were about 4 different contracts. We reviewed the contracts. There was issues with title to the property. We reviewed title. There was efforts to negotiate a forbearance agreement at the beginning of this, which were unproductive. Those efforts were undertaken. We drafted the complaint. We served written discovery. We had served process before that, obviously. There was a challenge to process and the service that was ultimately resolved by agreement to, I believe we withdrew and reserved. And actually those fees have been removed and were not charged to the client in the amount of $3,200 roughly, were taken off the bill and are not being sought here today on those service charges. There were different conversations regarding settlement between counsel undertaken. There was a failure by the defendant to respond to discovery in timely manner, and there was a 6.4 effort undertaken, and then ultimately documents and information was supplemented without the need to file a motion to compel. We took the deposition of the TXO representative and then ultimately filed summary judgment. It was challenged on multiple fronts, Your Honor, and with extensive briefing on that issue, ultimately resulting in the hearing before Your Honor, and then the order entered, and now an additional hearing on attorney's fees. So all that, Your Honor, was what was necessary and we believe reasonable in order to provide the services and to represent the client to where we are today. So, Your Honor, the total legal fees incurred, as shown on Exhibit 1, are $30,200 $30,292.50. That's the amount billed, circled. And then the expenses, which include things for service fees and parking and title searches and postage and some limited Westlaw, were $1,023.58. Total request, $31,316.08, Your Honor.
Mr. Capriola, one other housekeeping issue. I'm going to ask you to prepare a supplemental affidavit and file that so we have that in the electronic record.
Sure.
All right. All right, Mr. Friedman, you have any examination you wish to do of Mr. Capriola?
I'm not sure about examination, but I would like to question some of these line items that I've had an opportunity to review that were attached to his original affidavit. Before I do that, I'd like to preface this in saying that my general belief is that these attorney fees are high and not appropriate based on the fact that there was a good faith dispute between these parties. This isn't a situation where somehow like this was abusive litigation. I don't believe there's any allegation of that. And ultimately, the court did not side with defendants' arguments. There were extenuating circumstances here that, in my opinion, were worth litigating, specifically the fact that the escrow money was stolen, which was beyond my client's control, and also the fact that we could not get any kind of formal acceptance from the HOA that actually owned this building. And I believe that that was a reasonable thing to request before payment. Going on to the specific line items here, standing in my place, I've been practicing since 2007. The majority of my practice has been for insurance defense work. I'm very familiar with hourly billing and what is and is not reasonable. And I can say with high certainty that the numbers on some of these are beyond anything that any of my insurance clients would ever even remotely consider paying. When I practiced at Cruiser and Mitchell for a period of 6 years, specifically things like reviewing documents, 4.9 hours at $300 an hour. Even if it includes, like he says, these prepare draft of complaint, conferences, litigation strategy, that's a fairly exorbitant amount for, as he said, a simple breach of contract claim. There's also a lot of fees here for essentially work that was a mistake. And if you go back to the beginning of this case, the reason my client went into default because they served him through substituted service through the Secretary of State. That substituted service was defective. They knew where my client resided because the address was on their own billing of, Drake Thompson for TXO resides at 1280 West at this apartment. So when I entered the case, my first appearance was a motion to set aside the default judgment based on defective service. Because as a matter of law, as stated in our motion to open the default or set aside the default, you cannot use substituted service if you have actual knowledge where the defendant lives. And here they did, which is why they consented to opening the default. But you'll see here on the actual billing, although he says he took $3,000 off for service, what he did not take off is the actual service for that defective service. So you have line items for drafting documents for the Secretary of State. You have line items for reviewing the date of service through the Secretary of State. You have calls to the Secretary of State. You have everything related to the motion for default judgment, which totals like 5 hours. And the default judgment, because it was based on defective service, was also just a mistake. So if the court believes that attorney fees are appropriate here, and as I said, I think in general they're not because this was a good faith dispute, but assuming for the sake of argument that the court says, yes, I would like to award attorney's fees, I specifically do not believe those attorney fees should include things that were done in error. And I think all of those items should be removed. All of the attempts to serve my client through the Secretary of State, all of the line items related to the motion for default judgment. And that in itself looks like to me close to like 6 or 7 hours and would be a few $1,000s, if not more. So I object to all of those line items. I also generally object to the number of attorneys that are working on this. And I've had the same objection raised against my firm multiple times when I've been in a situation requesting attorney's fees where I believe it was Judge Purdom recently who told me in DeKalb County in his order that for a simple matter that myself and my boss, Matt Wetherington, working on the same claim may have been excessive, and he cut the fees of Matt Wetherington in half on that claim. This is as simple as Mr. Capriola said, contract claim for non-payment, and it looks like he's got at least 3 or 4 attorneys working on this, being supervised by a senior associate with 30 years of experience. Like I said, I'm not disputing the fact that they had to do work on this, but I am stating that this is highly excessive and if submitted to an insurance company would never get paid. I don't believe they would even pay half of this. Those are my general objections, Your Honor.
All right, so I'm going to ask you to do this, Mr. Friedman. I understand your general objections. I'm not persuaded by your general objections. First, as to the necessity for fees at all, I agree with your statement that there wasn't any bad faith. This isn't anything even remotely approaching 915-14, but the contract is clear, and the contract requires attorney's fees if they have to file suit and retain attorneys to pursue this claim. And they had a valid claim. They had to hire attorneys to collect the amounts and get a judgment. So they're due. I generally do not agree with the proposition that there is some cap on number of attorneys who can work on it. I think in many cases, having one or more very junior attorneys is much preferable and far more efficient than having a more senior attorneys, the work grouped with a smaller number of more senior attorneys. I think the number could reasonably be expected to be higher if the work had just been done by Mr. Capriola and one senior attorney. So I don't agree with that argument generally. I am receptive to the argument that some of these entries relate to work that was ultimately not successful or perhaps a mistake, or that some of these entries, the time incurred may be excessive. So what I would ask you to do, Mr. Friedman, is to send me or file a line item, which ones you think, and denote. Either you can color code it or you can handwrite it. Doesn't have to be anything fancy, but just give me some indication of which entries you think are excessive time and which entries you think are time that should not be counted against your client in the first place.
Understood. What I recommend then is this, because you've already asked plaintiff's counsel to essentially submit an up-to-date affidavit. Why don't we have him submit that affidavit? I will respond to the affidavit with a written response that identifies individual line items that says that I believe that these are either excessive or are based on work that should not be charged. And then the court can make a decision without having to hear from us again.
Your Honor, I would like the opportunity to respond to that because there's been no itemization for me to respond to. And generally, Your Honor, we disagree that there was a mistake made. There was a challengeable ability on that argument to put it before Your Honor. We were trying to cut to the chase and get to the issue of service. And I did reduce the bill by $3,200, intending to reduce it by all costs for that service. So I think that has been done. Now, if he would point out line items, I'd like to respond and say how that credit applied to those items. So I'd ask for that opportunity, Your Honor.
All right, so we're going to do that. Mr. Capriola, if you can get that updated affidavit within the next 5 business days, then Mr. Friedman, I'll give you 10 business days to respond. And Mr. Capriola, you'll get the final word 10 business days after that.
Thank you, Your Honor. That'll be just fine.
Thank you, Your Honor.
And then I'll rule on the paper. We don't need to have another hearing on this.
Excellent.
All right.
Thank you, Your Honor.
All right. Thank you both, gentlemen. If there's nothing further, y'all may be excused.
Thank you.
Thank you.
All right. Let's go to Favors versus City of Atlanta.
Good morning, Your Honor. Sam Starks for the plaintiff, and I don't know whether you can see me well. I can't really see myself that well either, but I'm sitting in a conference room with Sydney Marshall and Sean Williams, who are all sort of counsel of record for the plaintiff. Can you hear me? I guess that's the main question.
I can see you and I can hear you, so we're good.
Good morning, Your Honor. Stacey Miller from the City of Atlanta, the defendant. I'm joined here by my colleagues Jaquita Parks and Alicia Marie Nair.
All right. Ms. Miller, this is the city's motion for summary judgment. So,
Yes, sir.
so if everybody's ready, I'll let you go ahead.
Thank you, Your Honor. Before jumping into the substance of our motion for summary judgment, there is one preliminary issue that I would like to address. There was a question as to whether the motion for summary judgment was filed timely. And I did want to address that particular issue. The motion was filed on November 15th, which was the deadline set this court's scheduling order. However, there was an issue with File and Serve Express. And as soon as we were alerted to that issue, we did open a claim with File and Serve Express. We have an email from them stating that they would backdate the date of this particular motion to November 15th. And we can provide that email to the court. If the court would like, we could also get a signed sworn affidavit from File and Serve Express. But I want to address that particular issue as this motion was properly filed on the correct date and is properly before the court at this time.
I believe it's properly before the court. We're not going to preclude you from giving your arguments based on that short delay, and we understand the technical glitches can happen. So you may proceed on the merits.
Thank you, Your Honor.
Go ahead, Mr. Stark.
I'm sorry, Your Honor. Will I at least be able to be heard on that despite the court's ruling? The record as it stands certainly doesn't have a motion for leave to late file or any of what she's represented. And so I guess we maintain that argument with respect to our motion. This is the first time we're hearing this, Your Honor. And we don't have the proof of it. Put it on the record. Well, you need it for potential appeal issues. Yeah, you need to say, look, if this goes beyond this court. I think there's technical differences. That's what I'm saying.
All right, so Mr. Townsend is telling me that, you know, there is some confusion with the date and time stamp, that there's one version that's stamped a day late, but there's also another version that's timely stamped. I don't want this case to be a fight about whether or not it was technically filed right on time or not. I don't see any evidence that there was some willful disregard of the court scheduling deadlines. It's certainly not prejudicing anybody in terms of delaying the trial on this issue. My intent is to hear the merits and not to require any further proof. We've got a filing in the record that's timely that's timely filed. I'd hate to have this break down to an appeal issue as to whether the motion for summary judgment was timely filed based on some file and serve express glitch.
Your Honor, I guess my position is simply this. The only motion that I have seen, and the motion that I think is part of the record as far as we know, shows a file stamp date of November 16th. I have not seen a pleading or a brief that shows a file stamp date of November 15th. And I guess I would disagree with the court to the extent that we have a certificate of service that says November 15th, but we have a file stamp on the pleading that says November 16th at 9:15 a.m. And the extent to which Ms. Miller now makes representations to the court and to the plaintiff that this is what happened, we have an email that shows this is what happened. I would request, based on our argument and our motion, that it was not timely filed. I would request, for purposes of the record, that the extent to which she now asserts that there is excusable neglect that would justify why it was filed on the 16th, I would request that that be put on the record. I'm prepared to address the merits of the motion, but one of the arguments we make in our pleading that in fact does go to the way the city has litigated this case throughout is the timeliness or the lack of timeliness of that motion. And the fact that we haven't gotten the courtesy of this response, the response that we're now hearing today for the first time.
Give me one moment. I'm going to check the record here. Council, just give us a few minutes while I look back at Mr. Townsend's file and serve record.
Thank you, Your Honor.
All right, council. We have you back, Mr. Starks.
Yes.
All right,
Your
so I'm going to share my screen. Can you see that document?
I can see that. Yes, Your Honor.
Yes, Your Honor.
So, Mr. Townsend, if you would explain where this document comes from.
Yeah, can everybody hear me?
Yes.
Yes.
So this document was in my queue, my file and serve queue, and it appeared on 11/15, 10/25. I saw Mr. Stark's motion, and originally I saw that in the record that November 16th date, but then I went back and looked because I thought that was odd. So of course we had this November 15th stamp, as you can see, it's stamped by the clerk. There was another, obviously, kind of conflicting, that was November 16th. So, we went with the earliest date instead of, that later date. As far as I'm concerned, judgment of the review, but I put it on the calendar because, we went with that November 15th date. It is in file and serve. It did appear on my queue on that date, so.
We may need to add this to the record.
Yes.
But
Your
this
Honor.
is what we received in chambers and when we received it.
I'm sorry, Your Honor. You were breaking up a little bit. I'm sorry. Would you say that again, Your Honor?
Yeah, so we may have to supplement, I may have to supplement the record, so that document is in there, but we received it and we received it on that date, which would be timely.
No, I understand, Your Honor. And just so the record is clear, we did not receive it, and what we received shows a different date. And so my position is that I would like the record to reflect essentially what Your Honor has showed us, but also the filing that we have that says it was filed a day after at 9:15 a.m. And the extent to which Ms. Miller has represented anything about an error email, I would submit to the court that unless that is put in a motion for leave to late file or in some motion, those representations, I think, are not sufficient, at least as a predicate to say, well, it was timely filed. I'd like the record to be perfected as to what everybody's position is regarding the filing of this motion. And this is the first we've ever heard. And we inquired of the clerk's office and we didn't get the explanation that Ms. Miller is getting. So again, frankly, I am, as I sit here right now, if I were hearing all of this a week ago, I'd be making a phone call to the clerk's office to see for myself, did an error in fact occur and how did it occur? Now, maybe I'm just cynical about these things, Judge, but I do want the record to reflect that this was an issue that we addressed in our summary judgment motion. And frankly, Your Honor, let me say this, and then we can go to the merits of this. It is Your Honor's case management order that sets forth deadlines for filing motions and deadlines for other things. And we've complied with those as the plaintiff, even though that, frankly, to me, Your Honor, some of them are a little bit rigid, but we respect the court's discretion to set those deadlines. It's our position, and this goes to our attorney fees claim, that throughout this litigation, the city has shown a lack of courtesy and professionalism towards counsel for the plaintiff. We've had numerous hearings about discovery issues, and I would submit to the court that this is yet another example of that, because all Ms. Miller had to do when she saw our motion was respond with a reply stating what she just stated to the court, so that we have the benefit of looking beyond those representations. So to me, I don't believe the record is clear as to whether there's excusable neglect. And it's a motion that, from everything I've seen, but for the court's document today, it was not timely filed. But I'm just curious, Your Honor, how is it possible? Now, I don't do any e-filing, but how can I have a document that shows November 16th, 2021, 9:15 a.m. that has the same stamp that the one the court put up, but yours is different? I'm curious about that.
I'm curious as well, but I'll tell you this, Mr. Starks. I'm sympathetic to your argument about, the necessity to have conferences and discovery issues and push this case along. And, we've had conversations about that, and I've given some admonitions to the city in that regard on, delays and conduct in discovery. But this just isn't one of those circumstances. I mean, if there's any blame to be had, it's on the court and the clerk's office with confusing documentation and confusing filings. There is no doubt that we got this filing at 10:25 on the 15th. There's no doubt that it was filed. We couldn't have got it in advance of when it was actually filed. So if there is any mistake, if there's any glitch, it's on the part of either File and Serve or our clerk's office. And I'm just as anxious as you are to get to the bottom of it and find out what happened. But this one's not on the city. And yes, could they have eliminated this issue today by someone reaching out to you before this hearing and saying, look, Mr. Starks, here's what happened. I don't understand it either. Yes, you're absolutely right. We could have saved ourselves a lot of time if somebody from the city had reached out to you. That didn't happen, but I'm not going to penalize the city and deem it a late filing when it wasn't a late filing. So, and I'm not going to require them to supplement the record or make a make a request for a late filing because I'm finding, as a matter of fact, that it's not a late filing. And I mean, you can do with that what you will, but I suspect that it's not going to go past today. We're going to get to the merits and we're going to get our ruling one way or another, and we'll move on. So let's get to that, and let Ms. Miller do her argument.
Very well, Your Honor. Thank you. I understand.
Thank you, Your Honor. As I stated before, the parties are here on the city's motion for summary judgment, and we do believe that the city is entitled to summary judgment, and the plaintiff is not entitled to recover because the officers did not act with a reckless disregard for the appropriate procedures while conducting their official city business. And plaintiff has also failed to allege that the officers acted with any type of malice that would strip them of any official immunity. And plaintiff has also failed to join one or more indispensable parties. On the first issue of the reckless or alleged reckless disregard of proper law enforcement procedures, OCGA section 40-6-6D2 states that when a law enforcement officer in a law enforcement vehicle is pursuing a fleeing suspect in another vehicle, and the fleeing suspect damages any property or injures or kills any person during that pursuit, the law enforcement officer's pursuit shall not be the proximate cause or contributing proximate cause of the damage, injury, or death caused by the fleeing suspect, unless the law enforcement officer acted with reckless disregard for proper law enforcement procedure in the officer's decision to initiate or continue the pursuit. The Georgia Court of Appeals has held that reckless disregard, as stated in OCGA 40-6-6D2, means a conscious indifference to the consequences that are a result of that particular pursuit. Therefore, the plaintiff must show that the officers were consciously indifferent to any consequences that would arise from their decision to initiate or continue the pursuit. No evidence to this effect exists in the record. In the present matter, both the officers, as alleged in the complaint, Officers Camille and Officer Farrell, ensured that the APD Phoenix unit, which is the air unit, the helicopter, was overhead in compliance with their APD training. They also blue lighted the vehicle and attempted to execute a terminator stop during the felony stop. When the vehicles were already stopped, not while there was a high-speed chase in action or while others could have been in danger. However, the suspect, the driver of the vehicle, Mr. Jonathan Rice, was the one who was so determined to elude the officers that he drove on the wrong side of the road at a high rate of speed around a bend in the road and lost control of his vehicle, striking other vehicles, and ultimately running into the car that was pushed into a plaintiff.
Let me stop you. Let me stop you there, because there was something in the fact pattern that bothered me. At least for a period of the time that this incident was ongoing, everything seemed to be going according to regulations. We had folks just generally following, nobody's blue lighting. We've got the helicopter in the air, pinpointing the location, following the location. I can even hear on the radio traffic, discussion about trying to get a stop stick up ahead at some point. It just seems strange to me that when we're hearing we're going to try and get something up ahead of the car, that they try and run out the car from behind and put the stop stick in front. That doesn't seem to me, at least it raises to me a question as to whether they're disregarding the procedure. If the procedure is to make sure that there are units up ahead of the car to disable the car, why would they stop and try and approach from behind? Can you answer that question?
Yeah, yes, your officer. So the stop stick was initiated to disable the vehicle. The officers have discretion to determine when that stop stick.
Why did it have to be? Why did the stop stick have to be engaged then, when there's clearly discussion on the radio about engaging it ahead of them?
Yes, Your Honor. So the question is really, or the answer really is that the officers had that discretion to decide at that point, because at that point, the car was finally stopped. So of course, if you're trying to throw out a stop stick ahead of a car, there may be other vehicles there that are driving by. It's not a precise type of activity. So what the officer said, hey, we already have the car stopped here. The only place they can go is forward. So the officers believe, and that was why they believed that it was appropriate to initiate the stop stick at the stoplight where all the cars are stopped. It has less chances of injuring anyone else, any other cars, any oncoming traffic. And that was what the officers testified to, that once they got to that red light, they were like, oh, now we're stopped. This would be a good place to do the stop stick rather than waiting for traffic to continue and then trying to elude traffic and throw the stop stick out later at that point. So the officers decided that that was the best place to try to limit any type of injury to anyone else, any pedestrians or any other traveling motorists. So it wasn't that they totally disregarded anything that was in their training. They still have that discretion to decide exactly when the stop stick could come out. And that was what their decision was while we're at a red light, while we are stopped. So there's no high traffic, there's no volume of traffic going right now that would endanger others, then let's go ahead and initiate the stop stick.
And from your view of the record, when in this process was the vehicle blue lighted?
Immediately prior to them wanting to or attempting to engage the stop stick. Because you can hear it in the video as Officer Camille is getting out of the car, Officer Farrell, the driver, is blue lighting the vehicle.
Is that in accord with SOP?
Yes, Your Honor.
All right, go ahead.
As I stated just previously, that the officers did blue light the vehicle and they attempted to execute the terminator stop stick in an area where the vehicle will be stopped safely. However, the driver of the vehicle, Mr. Jonathan Rice, eluded the officers, drove on the wrong side of the road at a high rate of speed around a bend in the road and lost control of that particular vehicle. Although all of the requirements for engaging in a pursuit existed under standard Atlanta Police Department Standard Operating Procedure 3050, the officers, Camille and Farrell, did not engage in a pursuit. It was actually their intent not to engage in a pursuit. They did everything that they thought was necessary to not have to engage in a pursuit by attempting to deflate the tires as the car was at the red light. Now, after the car took off, we, of course, have an understanding from both the video and the helicopter video that other officers, not Camille and Farrell, were able to continue following the vehicle. Ultimately, Camille and Farrell were able to continue following the vehicle, and this was all after the vehicle had already crashed. Both Camille and Farrell testified that they did not even see the vehicle again before it crashed.
It seemed to me like as soon as they couldn't get the stop stick and they're blue lighting and he turns and goes, it sounds like to me, and it looks like to me from the video, that they're immediately after him. It sounds like there's at least to me a jury question as to whether a chase is on right at that point.
And Your Honor, I think it's very important that we look at the facts that were alleged in the plaintiff's complaint. It was that officers Farrell and Camille were the ones who initiated the pursuit and engaged in the pursuit. From the video and from the facts that we have in this case, that is not the fact. Those officers were the ones that were actually trying to Camille was actually trying to get back in the car. So how can they begin a pursuit if they're actually trying to get back in the car? And they flow with the flow of traffic to where the car was. So before they ever got back into the car had out into their police vehicle. The suspect vehicle had already fled and was going around the corner. And before they ever caught up with the car, although they were going with the normal speed of traffic and normal flow of traffic, the vehicle had already crashed and Mr. Favors, the plaintiff, was already injured. And because of this, Your Honor, the officers would be entitled to official immunity because they performed this particular action, the discretionary action of following this particular car, of attempting to initiate a felony stop, perform this without malice and without an attempt to injure these the plaintiff or anyone else, and with probable cause. This official immunity is particularly important in the context of high-speed pursuits, where the officers have to make a split decision on whether to initiate the pursuit or continue it, or what type of risk may be involved here. Your Honor, as a third matter, the plaintiff has failed to join indispensable parties to this lawsuit.
Yeah, Ms. Miller, you don't have to argue. You don't have to argue that one. I understand your argument, and I'm going to let Mr. Starks respond to it, and then I may come back to you for the last word on it. All right.
Thank you, Your Honor. So for those reasons, we believe that the city's motion for summary judgment should be granted.
All right. Starks.
Thank you, Your Honor. And I'll start from, I guess, the questions that the court asked the city in terms of the way this all transpired. As the court seems aware, there was a period of time when at least 2 police vehicles were following this stolen vehicle without any incident. No speeding, no reckless driving, and they were side by side at times following this vehicle. Over the course of a number of different blocks and streets, this is all on video. And during that same period of time, there's a helicopter that has a visual of this vehicle that's not speeding, that's not doing anything reckless, that's not driving erratically, with the police, 2 police cars following behind it. So Sergeant Fincher, I think, kind of says, in essence, what I think a jury would certainly be entitled to believe in terms of the flaw in all of this. If you take Sergeant Fincher's account of this, he basically says, once the helicopter has a visual of that vehicle, we're good to go. We don't need to do anything dramatic. We don't need to engage in a pursuit, because no matter where that vehicle goes, the helicopter will have that visual and be able to make that report. So I submit to the court that that is critical. That is something that a jury could certainly look at and say, the fact that you had this helicopter that had a visual, yet you decided to use the stop stick, and then when that failed, you pursued this vehicle, a reasonable jury could view that as being reckless. But in addition to that, Your Honor, and this goes to the use of the stop stick, certainly, arguably, they have the discretion to use the stop stick, although there is an SOP that deals with use of the stop stick. I think it requires supervisor's approval. I think it says you shouldn't do this in a congested area. What comes across in the depositions is that the plan that at least somebody had that wasn't followed was that we're going to just let this vehicle go. We'll get to a remote road. We'll place these stop sticks on the road. The helicopter's following the vehicle, so we're not going to lose it. And then once that vehicle is on a remote road where no other vehicles are nearby, no other pedestrians are walking the street, the stop stick will be placed and it will stop the vehicle. The officers, Camille and Ferreo, they jumped the gun. Sure, I guess, as Ms. Miller says, they had the discretion to do what they did, arguably, but they jumped the gun. And this was a pursuit that not only was unnecessary, but was also reckless. And so Ms. Miller, I think, is confusing the official immunity law as it relates to individual officers who are sued versus the city of Atlanta, who is the defendant in this case. The statute OCGA 40-6-6, that's a statute that came about as a result of people being injured and killed catastrophically, like Mr. Favors, as a result of high-speed pursuits by the police. And so essentially, this statute defines the cause of action and the standard that a plaintiff must meet as it relates to allegations against police officers when they are engaged in a pursuit. These officers are not sued in their individual capacity. They're not defendants in this lawsuit. So there is no question about official immunity or qualified immunity. This case is governed by 40-6-6. It's also governed by the automobile waiver immunity statute. And that statute specifically says, or a provision within that code says, don't sue the officers, you sue the entity. So I think the arguments about immunity or malice, totally misplaced, totally irrelevant. The other thing that I think is interesting about this pursuit is that even if all you did, Your Honor, was to watch the video and listen to the conversations that these officers are having in their vehicles. Ms. Miller says that I think Travis or Camille and Ferreo, who were these first two officers that were involved, she says, well, they weren't the officers who got out of the car and attempted to use the stop stick. They never actually engaged in the pursuit. That's not true. They say they engaged in the pursuit. If you watch their body camera footage, you see them quickly get out, then quickly get back in, and then quickly proceed to engage in the pursuit. There are 3 APD patrol cars that are engaged in this pursuit. The helicopter video shows the pursuit as this vehicle is going around the curve on Donnelly Hollowell, of all places where you have pedestrian traffic and vehicular traffic. And the first victim is Mr. Gilmore. And I don't represent Mr. Gilmore. Mr. Gilmore is not an indispensable party as it relates to Mr. Favors. As far as I know, the city has denied Mr. Gilmore's claim. They've told Mr. Gilmore, you don't have a claim. They've certainly taken the position that Mr. Favors doesn't have a claim. So I don't see how Mr. Gilmore is an indispensable party. The city seems to be suggesting that because there's this cap on the amount of coverage that would apply depending on how this court rules or what happens to Mr. Gilmore's case, that he is somehow an indispensable party. I suppose that would be an interesting question if they had tendered all that, if they had sort of tendered to the court $750,000 and between Mr. Gilmore and Mr. Favors, how do we divide that up? They're not indispensable parties, and the suspect, the kid in the stolen vehicle, and there's case law that addresses this. We address this. The police officers that are engaged in a pursuit where they violate the procedures of their department, and we enumerate, this was a pursuit that was without coordination and without supervision. And Sergeant Fincher says that, and he's the only supervisor that's involved. And his position is, I wasn't the supervisor over this pursuit, but he did supervise Ferreo and Camille, the 2 officers that initially followed the vehicle, and he told them to disengage, which is also evidence that a jury could look at and go, why did Sergeant Fincher tell his officers to disengage? Let the helicopter unit take over. He is doing that because there is no reason to pursue this vehicle when there is a helicopter visual of the vehicle. He tells his officers to disengage, but it's too late. It's too little, it's too late. By the time they get that message, Rice has already crashed into Mr. Gilmore. He's lost control of the vehicle, turning the corner, all on video. And then we have Mr. Favors, who, classic innocent bystander, standing on the sidewalk of a restaurant. And in one of the videos, you see all of this transpire. You see these 3 police vehicles that pull up behind the suspect's vehicle as the pursuit ends. You see the whole thing come to this tragic end where Mr. Favors tries to move out of the direction of the collision that's coming towards him, moves the wrong way and gets pinned against this wall, loses both of his legs, above the knee amputee. And as I mentioned, Your Honor, this statute, it came about specifically because of incidents like this occurring, where innocent bystanders were being killed by the police or being catastrophically injured by the police. It has been such a problem within the city of Atlanta that until recently, there had been an order from the former chief to no more pursuits. So I would submit, Your Honor, that there is, from the standpoint of the summary judgment standard, if this court gives the reasonable inferences to Mr. Favors, the benefit of the doubt and the conclusions that one can draw from those inferences to Mr. Favors, there is certainly sufficient evidence, disputed and in some cases undisputed, that this was a pursuit that was carried out in a manner, initiated and carried out in a manner that was reckless. And then we have Mr. Gilmore. There's an affidavit from him. He sees the vehicle being pursued. He gives us, it's nearly 100 miles per hour around a curve on Donnelly Holloway. So, Your Honor, I guess I could certainly elaborate on any other aspect of this that the court wants, but I believe that from the testimony of the APD officers, from the pursuit SOP, the video, in footnotes 7, 8, and 9, those are videos that I think show all of the critical events. It shows Travis and Flores following this, Lincoln then engaging in the pursuit. Depending on who you ask, there's a different vehicle in car number 1 versus car number 2 versus car number 3. But what we see in the video are 3 patrol cars that are engaged in that pursuit when that car crashes into the plaza and then causes the injury to Mr. Favors. And the only other thing that I want to note on the record, I did it by email, but there was a typo in our brief regarding this necessary indispensable. We certainly don't agree that Jonathan Rice is not an indispensable party as it relates, neither is Mr. Gilmore. And so I could also address that. What I cited to the court, which I think is the only, to me, the statute that sort of best defines sort of joinder and who's necessary and who's not, is OCGA 9-11-19. And so I cannot, it's hard for me to sort of argue against that, because it's just such a flawed argument to me. I just don't think, just as with the official immunity argument, I think the city is completely off the mark. That's just the wrong legal standard. Likewise with this indispensable part, just the wrong legal standard. And the only case they cite, I think, is this Poole case. These are fact-specific cases. They are based on what is the evidence that the plaintiff has. And there's case law that says, if you go to the statute talks about a reckless disregard for law enforcement procedures. If you go into the cases say the law enforcement procedures that we're talking about include the SOPs and the policies and procedures of the department. And so I think what we have here, and I've set forth just about every aspect of the pursuit policy, APD's policy, which is designed to prevent this sort of thing from occurring. They essentially violated just about every aspect of their pursuit policy. Thank you, Your Honor.
All right. I believe Mr. Butterfield, he is on or was on. I was going to give him a
Yeah, and I think he was only on, and I'll let him speak to this, but he represents Mr. Gilmore in an unrelated case, and so I think he is curious to hear the city's explanation of this, but I'll let him address the board.
Yes.
Oh, Mr. Butterfield.
Good morning, Your Honor. I know you're used to seeing me in a different capacity, but I'm just here as a spectator because we do have the companion case filed. I think it's before Judge Besson. We do represent Mr. Gilmore, and I'm just watching the arguments, Your Honor. I have nothing to add at this time.
Well, you know, this issue does affect you and your client, so I wanted to give you at least have an opportunity, since you're here, to weigh in, if you want to weigh in on the indispensable party issue.
I'll quickly say, Judge, that I agree with the position taken by Sam Starks on behalf of Mr. Favors. He and I agree in every aspect. We've been talking about this case almost on a daily basis. So every argument that Mr. Starks made, I would add, Judge, to that matter.
All right, and I will also let all the parties know that being made aware of this case and it arising out of the same transaction or occurrence, that case, your case, Mr. Butterfield, is being transferred to me.
All right, thank you very much, Your Honor.
And my intent is to have a further hearing with all the parties in both cases to discuss the issue of whether these cases should be joined. I haven't made a decision on that. I'm certainly not going to dismiss this current case for failure to join an indispensable party, but I am going to consider whether these cases should be joined for trial. So I just want to give all the parties notice of that.
If I can be heard, I may be able to help the court. There's also a third case, Your Honor. There is a third case before Judge Eady that does in fact involve claims against the individual officers for violating ministerial duties. It is the case that I had sought to join with this case, which the city opposed. And since they opposed it and delayed the case proceeding, it's filed as a separate case. From my point of view, Your Honor, and Mr. Butterfield can speak to Mr. Gilmore, I think all of these three cases should be before the same judge. Although there is an issue in Mr. Butterfield's case involving Mr. Gilmore, and in my second case for Mr. Favors, that's before Judge Eady, that is different. It is a different claim than the claim that's at issue in this case. But we've tried before to get all of this together, and I still think that would be advisable.
So how old or when was that the case before Judge Eady filed? And do you know can you give me parties or can you give me a case number?
I can do that in just a moment. The parties are Sergeant Fincher in his individual capacity, and Officer Ferreo in his individual capacity, and Officer Camille. And I'm going to ask one of my colleagues here to step out and get from the paralegal the exact case number for that. But that is before Judge Eady. And I don't have the case number, and I don't think I cited it in, although maybe I did, I thought perhaps I referenced it in this brief.
Yeah.
But it would,
Heard.
Go ahead, Mrs. Miller.
Thank you, Your Honor. The only issue with joining the first case, Stacey Favors 1, which is Stacey Favors versus City of Atlanta, with the second case, Stacey Favors versus those individual officers, was that the particular statute that this case is under says that you have to sue the city and not those individual officers. That was why the city objected to combining these two cases, because the plaintiff didn't want to amend the complaint to add in any other statutes. It was only to bring those officers in, and under the statute, those officers could not be sued in their individual capacity. So that's why there's two cases for that. With Mr. Gilmore's case, there's no reason for there to be a separate case because he did sue the City of Atlanta. Same case, same issue, same transaction, and a plaintiff and Mr. Butterfield as well have known about this case and knew that this particular plaintiff should have been added and did not do so.
All right, so
Argument.
So it sounds like what you're telling me is that the city doesn't have an objection to at least Mr. Gilmore's case and Mr. Favors' case being joined.
Yes, Your Honor. Yes.
All right, but there is still an outstanding issue as to the case before Judge Edie, and that's the one I'm going to do some more investigation on, but it would be my intent to at least have the case transferred to me since, you know, my guess is that this case is the one that's farthest along and that I have the most familiarity with the facts and the issues in the case. So it'll be my intent to have all three of them. Whether they all three get joined for trial, we can deal with at a later date. We don't have to deal with that today. So and Mr. Starks, if you can get that information, you know,
I do
it doesn't have to be right now, but if
I have it.
you have it.
It's actually, yes, it is in footnote number 16 of our brief. It's Stacey Favors versus Stevenson Camille, Ricky Ferreo, and Andrew Fincher, 21 EV 003762.
I see it.
And just so that, again, I don't want to make this, I don't want to make this confusing, but Mr. Gilmore's case, if I'm not mistaken, it has both the motor vehicle claim and the individual officer immunity claims. That is the separate Favors case before Judge Edie. So I think Ms. Miller is sort of confusing this. There are two claims that are in all of these cases. The motor vehicle related claim, which has the cap, and then the individual officer claims. They are in Gilmore as well. So again, I'm happy to have the court look at all of it and figure it out for everybody.
All right, we're going to look at all three. I think that if that's Judge Besson's case, it's definitely a later file case. They will hand that off to me in an instant and be glad to do so. So so I will have all three of these cases.
I do have.
We'll have a pretrial conference or a status conference to work through all these issues and get everybody's position on record as to whether these cases get tried together and how to handle scheduling and discovery to in the case that they are to be handled together, and we'll go from there.
Your Honor, if I may be heard on one other issue, I don't think I ever had an opportunity to respond to everything that plaintiff's counsel stated in their response to our brief before we got into the discussion of indispensable parties. Is that
Absolutely, you get the last word on the motion for summary judgment.
Thank you, Your Honor. So one of the things that I would like to address is the plaintiff counsel saying that there should have been no pursuit because the helicopter was in the sky. The helicopters had eyes on the vehicle. Yes, that is a portion of the proper procedures, and that was a part of what occurred on that particular day. But with all due respect, helicopters don't stop cars. It's the officers that are on the ground that actually have to determine exactly how to stop the vehicle. And so working in connection with the helicopter, they look for the best opportunity, the best information. And if the people were to get out and run, which they did, the helicopter is then able to tell the officers exactly where those people went, which is exactly what happened here. So having the helicopter there doesn't mean that there's no reason for a pursuit. It means that you have extra backup for that pursuit. And that is exactly what the standard operating procedures call for. And that's exactly what officers did in this particular case. And so the next question really goes to the proximate cause of this particular accident. What plaintiff is saying, well, everything was going just fine. There was no need to stop this vehicle. What plaintiff's counsel has omitted is that the vehicle there was a BOLO out for the vehicle as armed and dangerous. The officers had a right to stop that vehicle because it did come back as armed and dangerous. That's in the testimony of the officers and also in the testimony of the Clayton County lieutenant who put the information in the system for the BOLO to be sent. And so under Georgia state law, a particularized BOLO for a particular vehicle is enough to stop that vehicle. And that's exactly what those officers intend to do. But now what plaintiff's counsel is asking for those officers to, I guess, predict the future and know that the suspect, although he had been driving safely along all of this time, wouldn't stop, but would drive on the opposite side of the road, go around traffic, and then ultimately crash. That's not what the officers, they are deciding whether to stop a car. That's not what they have to take into account. That's not something that they knew. They knew that the car was armed and dangerous, and they knew that they could stop their car based upon that particular information. And the last issue I want to address is really the reckless disregard. So the standard is clear. It's a reckless disregard. It's not a, did you not do what someone else would have done? Is did you look at the procedure and deviate from them in a way that shows reckless disregard? There is nothing in the record here that shows that. What we have here is the officers having discretion to make a decision that was reasonable under the circumstances, and them making the appropriate decision. And therefore we ask that this court grant the city's motion for summary judgment.
All right. Initially, I'll talk about the matter of indispensable parties. I certainly believe there's an issue as to whether complete relief can be afforded as to all the parties and whether a non-party to this case could be prejudiced by a ruling or finding in this case if parties aren't joined. I do think that exists. I don't think dismissal is the appropriate remedy in my discretion. I think the appropriate remedy is, as I've discussed, is to gathering these cases together and making a further determination as to how best to get to a global resolution of all of them with all the parties available. I think there's some thornier issues with respect to the driver of the stolen vehicle, how he can be joined, whether he can be joined, who can join him, whether a notice of non-party fault would suffice, whether that's even viable in light of recent case law decisions and examining the apportionment statute. I think those issues are too complex and not fully briefed where I can make a definitive determination on those at this point, for at least at this point, the motion for summary judgment on that ground is denied. As to the substantive liability, I think there are clearly questions of fact as to whether the SOP was followed. I've reviewed the video. I think a jury could just look at the videos and look at the SOPs, and it would be in their purview to find one way or the other as to whether there was a deviation. And if there's a deviation, the question of what they knew about the procedure, how well they knew it, what they were advised at the time, and whether they recklessly disregarded it or just were simply negligent, that's a question of fact for the jury. I can't determine that as a matter of law from the evidence here. So the motion for summary judgment substantively is also denied. So Mr. Starks, if you would prepare a draft order denying the motion for summary judgment on all grounds, I think it can be general. Doesn't have to be detailed unless you want it to be, and then I'll take a closer look at it and adopt it as I would. But if you would submit a proposed order, send it to Ms. Favors in advance so you can approve or not approve as the form, and then we'll get the order entered. And I think the next thing we should look for is a status conference once I've got all three cases before me. Any other business?
Judge, case number for Gilmore, if you like it. Your Honor, would you like the Gilmore case, the case number?
We have it.
Frozen. Okay, all right, thank you, Judge.
All right. All right, if there's no further business on that case, counsel may be excused.
Thank you very much, y'all.
Thank you, Your Honor.
Thank you, Your Honor.
Thank you, Your Honor.
All right, Mr. Boyd.
We meet again, Your Honor.
Here we are again.
Yes, sir.
This hearing was noticed. Notice was sent to
Last Thursday, Your Honor.
to Mr. Alexander, as well as you. We did get a motion filed, was it yesterday, Mr. Townsend? Yesterday, Mr. Alexander filed on behalf of plaintiffs a motion to reconsider my ruling on the motion for reconsideration and to reschedule the hearing.
It's a new one for me, Your Honor.
I was prepared to let him argue his motion for reconsideration today if he appeared. But once again, I think exemplifying a pattern of failure to appear or late appearances, he is again not online for this hearing, this timely noticed hearing, this advance noticed hearing in a timely manner. Well, I'm going to let you go ahead and present your testimony and evidence as to your attorney's fees.
All right. Thank you, Your Honor. Just briefly by way of background, as I'm sure Your Honor knows, this originally rises out of our motion for fees that we filed on September 14, 2021. And as mentioned in our motion, we had tried to work this out with opposing counsel in advance of filing that motion, and unfortunately we're unable to. So subsequently, as Your Honor knows, opposing counsel then unnecessarily expanded the proceedings by untimely filing a motion for reconsideration with this court along with an accompanying motion to withdraw the prior admissions, which the court denied. But in the meantime, we did have to respond to that. We did have to file a responsive motion to that, and we did have to appear for that hearing. So at this time, Your Honor, in addition to the attorney's fees on the motion for summary judgment, we're also requesting attorney's fees for the present motion on the fees, as well as for having to respond to counsel's subsequent filings. So what I've done today is I've just kind of broken out for the court how those fees all break down. In connection with the motion for summary judgment, I would state my place that my firm has charged Bell South fees totaling $9,557.50 for the motion for summary judgment. And that work all included the time spent for preparing the motion for summary judgment, along with the supporting documents, reviewing and responding to plaintiff's objection, preparing for oral argument, and then also reviewing and responding to his first motion to set aside the admissions filed after the MSJ, and then preparing the order on the granting of the summary judgment. Now, Your Honor, we have included with our motion for attorney's fees an affidavit, Exhibit D there too, which outlines the fees that were charged on the motion for summary judgment. And briefly for the court, I can tell you that I had worked on that for about, it was 19.8 hours at $200 an hour for $3,960. That's when I was an associate. I then luckily got bumped up to a partner. I then spent an additional 5.8 hours in that proceeding for $1,305. We also had two associates that were working on that, Jessica Lawrence and Jasmine Pill. Ms. Lawrence spent 6.3 hours at $200 an hour for $1,260. Ms. Pill spent 14.5 hours at $175 an hour for a total of $2,537.50. And then my other partner, Mr. McKinley, spent a total of 2.2 hours at $225 an hour for a total of $495. And as mentioned, Your Honor, that's all laid out along with the supporting documents in our affidavit to the motion that we filed. So, you know, I would state again in my place as to the reasonableness of the rates. I've been licensed to practice law since 2010, originally in Connecticut. I moved down here and was licensed to practice in the state of Georgia since 2016. I'm a member in good standing in the State Bar of Georgia. The other attorneys who have worked on this as well are all admitted to the state of Georgia. Have all been practicing for several years and are all in good standing. So to my knowledge and based upon my 10 plus years of practice, I would argue that these rates are reasonable for lawyers in the Atlanta area with similar experience and skill. So accordingly, with respect to the motion for summary judgment, Your Honor, we would request, again, $9,557.50 in connection with that motion. As I also alluded to at the outset, Your Honor, we've also requested attorney's fees in connection with the motion for attorney's fees that we're here on currently. As mentioned, we had tried to work this out with opposing counsel at Your Honor's direction, and unfortunately weren't able to. So it state further in my place that we have, my firm has charged Bell South a total of $1,395 for work done, for which we were compensated $1,350. I suppose they found there was a 0.1 there that wasn't justified. And I would further state my place that we'll be charging Bell South at least $405 for work related to preparing and attending the hearing today. So again, we would request a total in that regards of $1,755. And for the reasons previously stated, we believe that the rates are reasonable and customary for Georgia. And finally, with response to the plaintiff's motion to reconsider, I state my place that my firm has billed Bell South at least $1,170 for that, and we will bill Bell South $540 for that work in connection with the hearing that we previously attended. So again, with regard to the motion to reconsider, we would ask for $1,710 on that. So in total, Your Honor, we're requesting fees of $13,022.50, which breaks down to $9,557.50 for the motion for summary judgment, $1,755 for the motion for attorney's fees, and then $1,710 for the response to plaintiff's motion to reconsider from last week.
All right, here's what I'm going to do. There was certainly dilatory conduct and a lack of attention to discovery and to discovery deadlines and to the rules of this court during the discovery process. And, you know, I think, as I mentioned at our prior hearing, I initially allowed plaintiff's counsel an opportunity to try and save their case by trying to withdraw the admissions, but told them that because of their conduct, they were going to have to cover your fees and having to get to this point. So I am awarding $9,557.50 in attorney's fees as a discovery sanction, not under 9-15-14. As to the subsequent fees under 9-15-14, you know, I recognize that counsel has been, that plaintiff and their counsel has been far less than diligent in attempting to resuscitate their case, and has delayed the ultimate resolution of this case and has caused fees. Typically, when I'm looking at 9-15-14, and this is the court's own view, I usually am looking for some kind of malice, some kind of bad faith, something above simply incompetence or negligence or inadvertence or even malpractice, but some affirmative desire to cause the other party unnecessary trouble and expense. Ultimately, on its merits, if we could have gotten to the merits, I don't think it was a meritless case. I think there was evidence that could have been presented that could possibly have gotten this case past summary judgment. It didn't happen. But I don't see any bad faith. I don't see any malice. I don't see any intent to injure or harm. I see inadvertence, neglect, and perhaps a lack of diligence. And I'm not going to award 9-15-14 fees on that basis.
Thank you, Your Honor.
That is my ruling. If you would submit a proposed final judgment on the attorney's fees as a discovery sanction, the 995-5750, we will get that order entered. I suspect there will be an appeal or some other kind of action to try and save the case. We'll deal with that. We'll deal with that if it ever comes back to me.
Thank you. And Your Honor, you had cut out, what was the section you wanted us to reference in the order?
I think it's 9/11/37. I think it's discovery misconduct, not.
I can look that up, Your Honor. And if that's not 9/11/37, I'll figure out what it is and get it over to you.
But I intended it as a discovery sanction, and I intended it to be conditional in order to allow a late response and a late amendment of admissions responses, that he paid reasonable fees. And, you know, I think the fees on this motion are high, but he has lost his ability to contest them. And certainly he caused extra fees by continuing to try and push this along, but never bring it home. So you're going to get that in total.
Thank you, Your Honor. We appreciate you. We appreciate your ruling.
All right. Thank you, Mr. Boyd.
Thank you. May I be excused, Your Honor?
You are excused.
Thank you, sir.